Hi, I'm Benjamin Dunlap, managing partner here at Norman Smith in Harrisburg, and I am here today to talk to you about trademarks and their value for businesses. So, first of all, give you a little bit of a background on federal registration. Registration of a mark is really the best protection that you can have, and it provides nationwide blanket protection for the particular use that you're using your trademark for. And it thus abrogates the traditional geographic limits of protection. Historically, trademarks were only you only have protection in the area in which you use them, and federal registration allowed you to get nationwide protection. And if you're only operating within a particular state, a less expensive way to get protection within that state is to just register for state protection, which here in Pennsylvania, and I believe in most states, is very simple to get. The good thing about federal registration is that it also provides what's called constructive notice of the trademark holder's rights. In other words, no one can, if you have federal registration, someone else can't come in and say, well, I didn't know that. Just the fact that you're on the register means that they are under a duty to look before they use any trademark. There are certain necessary attributes for a trademark, and the biggest one is distinctiveness. It must be recognizable, identifiable, and different from other marks. In other words, when someone sees your trademark, they associate it with your product or service. It can be a word or phrase or a word in conjunction with a graphic, which is very common. Word marks provide the most protection, but it cannot be a common phrase. In other words, a couple of years ago, Mariah Carey tried to trademark the Queen of Christmas because of her song All I Want for Christmas. And there are people who objected to that, who were also like to associate themselves with Christmas, and her trademark was turned down. Coined or fanciful terms not only effectively identify the source of goods, but they serve a marketing function on their own. Xerox, Exxon, or Kodak are very common terms. Everyone knows what products are being sold and are associated with those marks. And then there's drug names such as Ozempic are also areas where fanciful terms or made up terms are frequently used. An applicant cannot gain registration if registration would cause a likelihood of confusion. And there are various factors that are used in this determination. The first of all is a similarity of the marks. For Exxon, which we had on the last slide, you couldn't register EXON, for instance, instead of EXXON. They're just too similar. And especially if you're trying to sell anything having to do with fuel. Similarity of the products. If you are selling air conditioners and you have similar marks, that would cause likelihood of confusion. If you're selling snack food and air conditioners, there's a much less likelihood of confusion. The area and manner of concurrent use. If you are selling, snack foods again, that would be much less likely to get mixed up with a product, home improvement products that's sold in Lowe's. The degree of care likely to be exercised by consumers. Consumers generally, when we're spending more money, we are much more careful about what we buy, and we look at it a little bit more and consider it. And there's less likelihood of confusion versus a snack food in a convenience store. The strength of the mark, if there's something that people really associate with the mark, Tide for laundry detergent, for instance, that's a very strong mark. Then if someone has something like that, called maybe ocean currents or something like that, they might not be able to get registration because of the likelihood of confusion. Actual confusion, if someone is using a mark that is close to yours, one of the ways that you can get them to keep them from becoming registered or have their registration revoked is to have a survey showing that consumers actually do get confused by the two marks, that they can't tell the difference. And then, of course, wrongful intent, and that's very hard to show that that someone intended to have their product confused with yours. But if you can show that, you're pretty much golden in getting their mark, keep it from being registered. Secondary meaning. Marks that are merely descriptive generally cannot acquire trademark protection. For instance, you can't register the word onions, but you can register Vidalia onions, which are onions from a particular part of Georgia, a particular area of Georgia. Secondary meaning is acquired through use in the marketplace that makes the marks distinctive of the owner's goods or services. And secondary meaning comes into play where the mark is not super distinctive on its own. And if you have a mark like I did for one of my clients, Lancaster Online, which are two fairly common words, the client had been using that for 5 years, and so we were able to obtain registration because there's a presumption under the law that after 5 years of continuous use, that the mark obtains secondary meaning associated with that particular product or service. And owners of marks have to be careful that that their mark is not lost by that their protection is not lost by overuse in the marketplace. It must be associated with a particular product or service. And once a mark is associated with a general category of aspirin for pain relievers or cellophane for plastic wrap, then those registrations can be lost. Marks that are merely surnames cannot be registered, but if a mark is associated with a particular product in the relevant markets, such as McDonald's is with fast foods, then the licensed status of a surname is relevant. Until recently, trademark registration had been unavailable to marks that consisted of immoral, deceptive, or scandalous matter, and the trademark office made those kind of determinations. And also marks that, quote, disparage persons, institutions, beliefs, or national symbols, or bring them into contempt or disrepute, could not gain registration. That was struck down in 2 recent cases. The first concerned a musical band that wanted to register the name The Slants. And the trademark office said, no, that cannot be registered under the law because it's disparaging to people of Asian descent. But the court held that that provision was facially invalid under the First Amendment in that it prohibits speech based on viewpoint. And in fact, the band members said that they wanted to use this term, which is generally a slant to a group, an ethnic group, because they wanted to reclaim the term and drain the term of its denigrating force. Similarly, the immoral and scandalous matter provision was struck down in Iancu v. Brunetti a few years later. There, the Supreme Court said that the USPTO's refusal to register the mark FUCT for a line of clothing was discriminated based on viewpoint in violation of the First Amendment, and that was struck down. So that's a little bit of an overview of trademark registration, which, as I mentioned, can be very, very important and valuable for your products and marketing them. So if you ever have any questions, I would be very happy to help. My contact information is there on the screen. And I look forward to hearing from you. Thank you.